All right, Carol, it looks like we're good to go.
Wonderful. Good morning, everyone. Welcome to the Connecticut Paid Leave Policy and Personnel Committee. Today is February 1, and I would like to have a welcome call to order through Amber.
Good morning, everyone. Ava Bermuda Zimmerman.
Present.
Britt Marie Cole Johnson.
Present.
Carol Dzinski.
Present.
Mike Soltis.
Present.
And Paul Petanianos will not be joining us today. Carol, we have a quorum.
Excellent. Thank you. I'd like to acknowledge any public members.
We do not have any senators or representatives with us, but thank you everyone for joining us.
Thank you, Amber. Currently, the review and approval are January 4th, 2022 meeting minutes. Any concerns, discussions, or errors?
None.
Seeking a motion?
Move to approve the minutes from the last meeting.
Second.
All in favor?
Aye.
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 Against? Excellent. All right, meeting's passed. The excuse me, the next topic is our discussion regarding proposed policies. To Erin.
Good morning. Let me go ahead and share my screen. Actually, Andrea or Amber, could you?
You're all set, Erin.
Great. Try that again. So
See your note, Britt Marie.
just want to give you a heads up about some policies that we're going to be sending around for your review and consideration. We just want to give you a quick heads up about them. On the Finance Committee will be familiar with some of these. We have a series of policies relating to our contribution collection efforts. So we want to make sure we are clearly defining when the contributions are due and when they're late and what constitutes proof of submission. We also want to establish more clearly our authority to estimate contributions owed based on various sources and specify the process by which employers could submit documentation to us to support their estimate of the calculation, their contribution estimate. We also wanted to clarify when we receive late payments, the order in which we'll attribute those payments to the quarters owed, and what we'll do if the payments are incomplete or insufficient. Finally, we wanted to clean up the penalty provisions that we had adopted in December to just make them easier to administer, including just applying a 10% penalty for all offenses. We originally planned on escalating the penalties for first, second, and third offenses, but the administrative burden of doing that actually exceeds the value. So we think it's just straighter and easier to apply the 10% each time. And also to specify that really the penalty applies to the employer, not to the TPA. And if there's some issue between the employer and the TPA about why a penalty is late, that would be resolved, or why a penalty is owed, and why contributions are late, that would be resolved between them. But statutorily, the obligation to remit is the employer, so that's where we want to place the penalties. Any questions about the contribution-related policies before I move on? Okay, and as I said, we'll share these with you. And then additionally, we wanted to talk about a few other issues. The first is in connection to the impact of statutory changes to minimum wages on benefits. This is an issue that we had originally included in our consolidated policy documents, but then asked the board not to adopt in December because we wanted to spend a little more time thinking through the issues and options. And basically, we're changing course, or we would like the board to change course. All of our definitions relate back to what constitutes your base weekly earnings, which relates back to your highest two income quarters in the first 4 of the 5 most recently completed quarters at the time that someone applies for benefits or receives benefits. And so if we really are basing all of our calculations as of the date the benefits begin, logically, any change to minimum wage should not result in changing the benefit payments for in-flight claims. So this is a change, but it's something that we think is actually both better supported by the statutory language and better and easier to administer and more consistent with the way insurance industry works and benefit payments in general work. So we're going to make that recommendation. We also have developed an explicit policy relating to the confidentiality of claimant and other information. We have it in a sort of a variety of places that the data that employees provide to us and confidential financial information, confidential medical information needs to be remained confidential. But as a matter of best practice, we wanted to have a single policy which explicitly states for our employees and any contractors or vendors that they can only access or review that data for programmatic purposes, and that any sort of attempt to access or use the data for any non-legitimate purposes will give rise to disciplinary action and can give rise to vendor consequences as well. And then we will require our employees to acknowledge receipt and understanding of the policy and require vendors to ensure that their employees understand the policy as well. Again, not really a specific concern or a particular concern, but more a matter of best practice to have this. We know other agencies have it, and it's just something we wanted to button up. And then finally, we have some technical changes that as we go through, we just sort of notice gaps, such as making sure we have knowledge of severance pay in a material change, which we require employees to notify us if they have material changes while they're receiving benefits. We wanted to add severance pay to that. We also want to simplify the employment verification form to specify that if an employee works a regular schedule, they're always working 40 hours a week, they always work 22 hours a week, they can just tell us that rather than write 40 hours 12 times on the form. This next one is technical, but I just want to take a moment to explain it. There are 2 types of leaves that require employer agreement. First is if a person wants to take intermittent leave for the purposes of bonding with a newborn or new member of the family. Under FMLA, the employer has to agree to allow for that intermittent leave. Second is for qualifying exigency leave. There are a number of statutorily listed reasons that count as qualifying exigencies for an employee to take time off from work if their parent, spouse, or child has been deployed into the military. But then there's leave reason number 9, which is any reason that the employer and employee mutually agree qualifies as a qualifying exigency. Our general practice is that if the employee tells us and the employer verifies that they have reached an agreement to allow intermittent bonding or to allow qualifying exigency leave number 9, then we'll provide benefits for it. But if we have independent contractors or unemployed individuals who apply to us for leave under the statute, there is no employer. So we don't feel that they qualify for either of these 2 areas because there's no employer agreement. So we just want to put that into the language. And then finally, our policies right now say that we will pay basically 2 weeks in arrears, but we're working to improve that. So we don't want our policy to say we have to wait 2 weeks if we can pay faster. So those are the technical changes that we are proposing. As I said, we will share the actual documentation with you for your review and comment, but we just want to give you a heads up. So I'm happy to take any other questions.
Aaron, I have just one question. Thank you. And this is more about the substantive law than your proposed changes. How does severance pay affect receipt of benefits under our program?
So, it, depending on the way it is structured by the employer, it could be considered income replacement benefits. So if it's structured so that the employee is going to continue receiving a paycheck for the next 6 weeks, for example, and they're technically still considered to be on the employer's books, then that's income replacement that we would need to know about. So we just want to make sure that we can ask that question when we are making the determination about whether the employee is receiving other benefits. This is something that DOL recently, within the last 2 to 3 years, I think, were able to address with their unemployment. So we wanted to make sure we're being consistent.
And I know DOL used to, and Daryl could correct me if I'm wrong, if you had to sign a release as a condition of severance, it didn't impact your unemployment. Does a release factor at all into receipt of our benefits?
So that's a really great point, and we may need to be more clear as we write that, because when you sign a release, the money is not just straight up income replacement, it's actually consideration for giving up your right to sue. So I would say that's not sort of the same income replacement as 2 weeks pay in lieu of notice, right? So we're really looking at that 2 weeks pay in lieu of notice, as opposed to something where you're getting money in consideration for waiving your rights or other, or sort of something other than wage replacement. So I think we'll have to make sure we're clear about that.
Okay, thank you.
And Aaron, just a question. Curious, when the authority receives data from the Connecticut Department of Labor about wages being paid out, does it differentiate between sort of being paid in lieu of notice versus severance pay versus anything else, or does it all just show up as wages being paid to the employee?
If the employer categorizes it as wages to DOL, then that's what we know. We don't get there's not a lot of differentiation in that data.
Okay.
So the employer will report severance, vacation pay, wages in lieu of notice, WELON, that type of thing, to the Department of Labor as gross wages and then contributory wages, etc. There's no breakout or distinction. This is earned, this is severance. There's no distinction there. So we'll get it as a lump sum, part of a quarterly return. Michael, the severance in which an employer requires someone to sign an agreement with the employer that waives their right to sue, typically is a condition in which the person is giving up their legal rights, and therefore, I think to your point, we would consider it non-allocable and pay unemployment as well. The law is changing, has changed in the Public Act 200. So effective January of 2024, we'll be making changes around benefit payouts for our customers in the unemployment world. So this is a moving target, and Aaron, if you're thinking to converse with DOL about the changes, I'm not saying to be in alignment, but just to understand how we're moving, we can do that as well.
Okay, great, thank you. So I stopped sharing, but I can share again if anyone had any questions about anything more specific.
I do have a question to the contributions policy, the first slide. I forget, and I don't know if we've talked about this, but where will the recovery of the penalty to the employer reside? In other words, what are we doing with that money? And I have suggestions if it's not declared.
So in terms of I'm just making sure I understand the question, in terms of the actual contributions that are owed, or are you talking about the penalties that we receive?
The penalty assessed to the employer for their late contribution. Once you recover that 10% penalty, what's the purpose of that money? Is there an intended purpose? Is that open?
Michael or Dave, you can jump in. I don't believe we have specified a specific purpose for those funds.
Yes, that's correct. We haven't identified a specific purpose. It would just go into the trust fund with the remaining contributions.
All right,
And just to add, and sorry, Daryl, we may need to engage with an outside party and there might be expenses involved with that. So some of the
Sure.
penalty might be to pay for a collection agency or something like that. So that also is potentially.
So Michael, on a collection or a outside resource, if at all possible, I would recommend that the employer pay all the fees that required you to utilize in such recovery. Obviously, I think you'd be trying to do it yourself with your team, the delinquent accounts and the tax area or contribution area. And then if that all fails, you might have to, get a marshal, a superior court, wage garnishment, something. In any event, Aaron, my thought is 10%, no matter what that looks like. I don't know if it's going to be small amount, medium, whatever it is. I believe a discussion should be had around it going back to the authority and not to the trust fund for the purpose of supporting payroll to do more around contributions, recoveries, recovering those outstanding monies. So you might have to hire more staff, et cetera, but you also may want to use it around integrity. And, we never know what the future is going to bring. I can tell you firsthand, the criminals are out there throughout the world. And you might need to purchase additional technology or staff or both. And having that money available to you in crisis mode is certainly something that would be a nice placeholder. So my recommendation is it would not go to the trust fund to pay benefits, but it be used for the administration of the program to continue to improve and enhance the authority.
Thank you for that suggestion. I think that's not currently in the policy that we're planning on sending around, but I think we'll talk about that and see how we can work through that. Other questions about the proposed policies before we share them with you, and then share them with the board and post? I think everything except for the minimum wage will need to be publicly posted. The minimum wage policy was already publicly posted, and this is just kind of the result of further consideration of the comments we received. So that one we won't have to post again, but all the others will be publicly posted for notice and comment after we talk to the full board.
And Aaron, just on that monetary, the outcome would be someone who is determined to be eligible for X dollars in a weekly insurance payment that would continue for their duration, and it wouldn't be modified based on a change in minimum wage.
That is correct.
Good.
Ava, I see that you have your hand raised.
I just wanted to, out of curiosity, the policy effect on those who could potentially be union, and if what the review was between any collective bargaining agreement for any potential unionized member and the policies that are at hand.
So I'm assuming you're not talking about the unionized employees of the state of Connecticut who aren't participating in the program, correct? You're just talking about employees in the general workforce who work for covered employers.
In the
who may be
general,
in a union.
that's correct. Yes.
Yeah. We are certainly aware that this program is new and therefore is not something that most bargaining agreements have even contemplated. but, you know, we can't really undertake to assess impact on collective bargaining, any particular collective bargaining agreement. I think certainly the policies that we've identified here really are about our program, which is sort of outside of the employer-employee relationship. This is just the applicant and us. So it shouldn't impact. I don't know that it would necessarily impact any sort of collective bargaining agreement. One thing I think we are specifying is that penalties have to be paid by the employer. They can't be, employers can't use contributions to pay interest or penalties. So that, I think, is sort of the only area where you might see kind of an bleeding over into the employer-employee relationship. But was there any particular policy that you were concerned about?
No, usually in collective bargaining agreements, there's at the very end language that says that Connecticut regulations and law supersedes any language within the collective bargaining agreement. But I'm just the relationship. I've been getting a lot of questions about the relationship and, you know, what happens next, and I don't have clear answers for those people asking me other than talk to Aaron.
Yeah, I mean, I don't know that any of these particular policies are the ones that have prompted those questions. We have gotten questions in particular about the impact of other employer provided income replacement benefits and the paid leave benefits. And, you know, if an employer has negotiated to provide short-term disability policy as part of its collective bargaining agreement, you know, nothing in our statute prevents the employer from honoring that agreement. Nothing in our statute prevents the employer and the union from, you know, potentially renegotiating that agreement, taking into consideration that these benefits are also available. So, so we do sort of get those questions, but I don't think any of these policies in particular would affect those conversations. And can happily talk more about the general issues offline if you'd like to.
Thank you.
Right, I will stop sharing again. Thank you for your attention to this issue. And as I said, we'll share the actual policy language with you so you can review them and send your comments back just to Michael and me, not to each other, so we avoid inadvertent digital meetings. Thank you.
Thank you, Erin. The next agenda item is with David Marcone, an update on the Connecticut paid leave staff wage adjustments.
Thank you, Daryl. Good morning, everybody. I'm going to share my screen.
You could be all set, Dave.
Thank you. Okay, can everybody see?
Yes.
Fantastic. Okay, so we're going to spend a few minutes talking about employee wage adjustments for what we plan to do over the next few months. So we'll start off with some background information on employee classifications. So as of the beginning of this year, this calendar year, January 2022, the authority now has employees that meet the criteria where they are now part of a collective bargaining unit. So as a result, the paid leave authority will now have some employees that are in a bargaining unit and some that aren't. For those employees that are in a collective bargaining unit, they can earn increases to their compensation two ways. One way is annual increments, and the second way is a general wage increase. The first way, annual increments, which is also known as step increases, if you're within the state, those usually occur on January 1. Having said that, there haven't been any, the ones that normally would be for this year, for calendar year 2022, haven't happened yet because the state is still negotiating with the union. So the existing pay plans that were effective for fiscal year 2021 are still in effect. Now, historically, the annual increments have sometimes been granted retroactively back to January 1, even though the negotiations were finalized after that fact. The second kind of increase is the general wage increase, or that's sometimes called the collective bargaining increase. And that's because it's collectively bargained to a base annual salary. Historically, those take effect on July 1 of a calendar year. Now, the authority itself cannot negotiate directly with any of the bargaining units. And as of right now, we think there are we believe there are two bargaining units that the authority will be a part of, perhaps a third. The OLR, the Office of Labor Relations, is the state's authorized bargaining representative, and they are the ones that negotiate with the bargaining units. So that's the background of bargaining units. Now, since the authority started in the first quarter of 2020, which was almost 2 years ago already, if you can believe it, there haven't been any wage increases at the authority. Now, our current fiscal year budget does include a potential 3% increase for all employees effective January of this year. And the reason we put that in there was in order to be prepared for the possibility of bargaining unit increases. We didn't know the amounts at the time, so we used 3% for budgeting purposes. So we are recommending the following. Number one, we're implementing the increases that we're obligated to pay for the bargaining units when they become effective. The second item is for all employees of the authority who've been here since March of 2021 or earlier, and they're not already eligible for any increases from a bargaining unit. We would like to implement the 3% increase as budgeted in the first quarter of this year, because these employees have been at the authority at least a year. A lot of them have been here a year and a half, almost 2 years, and there hasn't been an increase. And then going forward, the goal is to mirror as close as we can the increases for all employees in a non-bargaining unit to be as similar as possible to those in a bargaining unit in terms of timing and amounts, so the increases are equitable across the entire authority. Does anybody have any questions?
This is Mike. Just in full disclosure, we discussed this at the Finance and Audit Committee. And my only observation, first two bullets, I'm completely on board with. Third bullet, I would just want to recognize that to the extent the law allows, and I realize it's very limited, we should reserve the right to address whether it's called performance or merit with the non-bargaining unit employees. Not making any decisions today on to what extent, obviously, but at least reserve that right going forward.
Right. Thank you, Mike. Anyone else? Okay.
Excellent.
Thank you for your
Thank you,
time. I
David.
appreciate it.
Appreciate it, David. Next agenda item is old business. Any old business? Any new business? All right, looking to adjourn.
Move to adjourn.
Second.
Thank you, Michael and Ava. All in favor?
Aye.
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 Aye. Oppose? Abstain? Thank you, everyone. Have a good week.
All right, thank you.